Supreme Court justices to conference tomorrow on the ObamaCare case. I am Matt Staver, founder and chairman of Liberty Counsel. Joining me is Matt Barber, vice president of Liberty Counsel Action. Matt, tomorrow is November 10, and the United States Supreme Court justices on Thursday will get together and conference on a number of cases that are being requested to be reviewed at the United States Supreme Court, among which are 3 ObamaCare cases, of which one of those cases is our case, Liberty University versus Geithner, that Liberty Counsel represents an employer, Liberty University, and 2 private individuals.
Well, that's right, and we have filed a reply brief in support of our petition for a writ of certiorari, and that means we're asking them to take our case, our Fourth Circuit case, that they can look at on the merits now. We've talked about it on Faith and Freedom because 2 of the justices that essentially said that our Obamacare case, that it was part of the Anti-Injunction Act, precluded them from actually until the tax, as they called it, goes into effect. They couldn't really rule on it. However, 2 of them did address the merits, so that would give the Supreme Court the opportunity to actually rule on the merits.
Yeah, they've got 3 cases. One of them is the Florida case with the 26 attorneys generals.
Right.
They challenged the private or the individual mandate, and they also challenged the Medicaid changes. And then there's the Thomas More case out of Michigan, and they challenged the individual mandate. And then there's our case, and we challenged both the individual and the employer mandate.
And ours is unique in that regard. We're the only case before the Supreme Court that actually challenges the employer mandate.
That's right. So we've got 2 unique aspects. One, we challenge the employer mandate. No one else does. And secondly, our case, 2-1 decision, they came down and said that the Anti-Injunction Act applies, meaning that if this does apply and it is a tax, then you have to pay the tax in most cases before you mount a constitutional challenge. Not in all cases, but in most cases. There's some rare exceptions.
It's the Anti-Injunction Act, right?
That's right. And the interesting thing is that the Department of Justice, arguing in defense, argued that the Anti-Injunction Act does not apply. And these are the people that are representing the government. This is the federal government, and they're interpreting their own statute of Obamacare, and they're saying that the statute itself and Congress itself did not intend to have the Anti-Injunction Act bar litigation on this case. So this is the government with its own statute saying it doesn't apply. We say it doesn't apply, and yet 2 judges said that it does apply. Those are the only 2 judges in the country of 17 or so that have come to that conclusion. At any rate, that's a preliminary issue that must be addressed. So it is very likely, as the Supreme Court justices meet tomorrow, that they will take one or more of these cases. We don't know exactly which one, but it is very likely that they would take the Florida case, or at least a component of it, because it struck down the law. Yeah. And then it's also a probability they'll take maybe one more case. And they'll hold at least one of the other cases. And it's a possibility they could take our case as well and address the Anti-Injunction Act as the matter that you have to issue and conclude before you get to the merits, and then address the merits. And then they could also look at the merits as it relates to our case with respect to both the individual and the employer mandate. So big day tomorrow. Now, we won't know anything until next week. And usually they conference on Friday. But Friday this week is a holiday. It's Veterans Day, I believe, November 11th. So they moved it up to November 10. And then Monday would be the first possible day when they're back in session, sometime after 10 o'clock, that they would release a list of those cases they decided not to take and those cases that they decide to take. Now, it's possible they could carry that over to another day, but the first possible day that we'll know what they decided tomorrow is Monday, which is November 14th.
And as you mentioned, Matt, every other judge that has taken a look at this have ruled that this is a penalty, which the government itself says this is a penalty, not a tax. Now, 2 of the 3 judges on this panel ruled that the Anti-Injunction Act barred their ruling on this case, or even the lawsuit from going forward, because the tax, as they call it, they ruled it was a tax, would not apply until 2014, as you mentioned. Every other judge in the country has ruled the contrary, that it is in fact a penalty. it's interesting, and we really weren't surprised that the court would punt on this when you consider that two of the judges were Obama appointees, and one was a Clinton appointee. It makes me wonder, this is speculation, if they thought maybe the path of least resistance here would be to just kick the can down the road. But I find it interesting also that two of the judges said even if the anti-injunction tax bars us really looking at this or the lawsuit from going forward, it's still constitutional. So
that's right. Yeah. So they ultimately still reached two of the three reached the merits of the case.
Yeah.
Now, one of them said it was should be upheld under the Commerce Clause, and has a very broad definition of that, saying essentially that it's not unusual for government to force people to buy things. In fact, government, and he reasoned like this: government can put a tax on certain people, and then from that money they can purchase things, and therefore they're essentially forcing you to buy it because they're taxing you and then they're purchasing something.
Wow,
which that's kind of a leap.
If that's the case, then the Commerce Clause would allow the government to force you to buy anything. If that's the argument that's being made here, if they want us to go out and buy a General Motors vehicle.
Well, Congress uses the tax to establish a military. And they use your money to establish and fund the military, right? Well, using that analogy, they could force you to be a part, force you to actually establish your own military. It's just kind of bizarre that because Congress can tax you and then they can turn around and use the money and do certain things with it, then therefore they can force you directly, even though they don't have the power to tax. And that's what his idea was, is that they essentially force you to do things by taking your money from taxes and then putting it on things that you may not like. So consequently, why can't they just force you initially, without the tax, to buy it yourself?
Yeah, such a novel idea, in fact, that it seems to me that as the U.S. Supreme Court goes to conference on this, that they might be interested in taking a look at that.
It's very novel, yeah. I've never heard that argument before. So it's pretty novel. And I guess, his essential argument is that if they can tax you and then set up a Medicaid or Medicare program with your money, then they can force you into it anyway. Well, the problem is that Medicaid and Medicare are voluntary. You don't have to accept it. Anyway, he's got a broad view of the Commerce Clause, which, if accepted, would mean that government could force you to do anything.
And the United States Supreme Court has a history of rolling back the really abuse of the Commerce Clause over the years in cases like Morrison and others, and saying, you guys, you're taking it too far. And in the Morrison case, for instance, with the
the Violence Against
Women Act, the court said that you're taking the Commerce Clause too far. I would argue that Obamacare far surpasses.
It goes much further than
that act.
Because it actually forces people into the stream of commerce that they don't want to be in that stream.
So I think Morrison sets a pretty high bar for the federal government to get over.
It'll be a big case, and so if the Supreme Court decides to accept one of these cases or more of them, and I'm sure that they'll accept one or more of the cases, and it's highly likely that they'll accept two or maybe more, and have oral argument, then if they were to make their decision next week, then briefs would be due 45 days from now at the end of the year. In other words, the first brief would be due. The opposite side has time to file a response, and then there's a reply. So probably oral argument would be sometime in February, March, maybe April, with a decision no later than the end of the term, which would be the end of June 2012.
Well, I encourage people listening right now to pray for this tomorrow, to pray that the Supreme Court justices would be guided, that God would give them wisdom in how to handle this Obamacare monstrosity, one of the worst abuses of federal power, I think, in the history of our nation, and that they would turn back this encroachment on our individual liberties.
Yeah, that's exactly right. We'll keep you involved. We'll let you know next week what's happening, but pray for the cases tomorrow as they're being conferenced by the United States Supreme Court justices. 9 justices will take a look at these cases and make a decision what they will do in terms of whether they will take them, and then ultimately we will then be in the next phase, and that is briefing and preparing for the argument phase for 2012. Give us a call at Liberty Counsel, 1-800-671-1776. All of the cases that we are involved with, we do pro bono at no cost. We can't do that without your prayers and financial support, so make sure that you continue to keep us in your prayers and your financial support. Go to Liberty Counsel's website, lc.org. Sign up for the Liberty Alert email. and then also the Grassroots Action email. We have now over 500,000 people on that activist email, one of the largest activist emails in the country. You can do that right from Liberty Counsel's website at lc.org.